My name is Judith Blumenau. I'm a family law attorney practicing in Oakland, Wayne, Macomb, Livingston, Lapeer, and Washtenaw counties in southeastern Michigan. My telephone number is area code 248-593-9090. My website, www.judithblumenau.com. There are various ways to reach a settlement in a divorce without having a trial before a judge. One of those alternative ways is through arbitration. The arbitrator is the decision maker in resolving all the issues that are given to him or her. Arbitration is a voluntary process where you and your spouse agree to submit some or all of the issues to a trained, experienced, neutral third party who is paid by both spouses to hear and decide their case and make an award that is binding on both parties. The arbitrator's decision is made in much the same way that a judge would make a decision. However, arbitration is a less formal venue. Arbitration is voluntary. The court cannot order the parties to submit to arbitration. The parties both pay for the services of the arbitrator, unlike a trial where there is no cost for the judge to hear your case. The arbitrator has to be an attorney in good standing with the Michigan State Bar, must have practiced in Michigan for at least 5 years, and have expertise in the area of family law. The arbitrator must also have training in handling cases involving domestic violence. The Domestic Relations Arbitration Act requires that the parties sign a written agreement laying out the subject of the arbitration. The arbitrator administers oaths and they issue subpoenas. They can issue an order requiring discovery. They can allocate the arbitration fees between the parties and enter an order requiring the parties to produce information that the arbitrator considers relevant and helpful in resolving the issues. After the arbitrator is appointed, the arbitrator meets with the parties and the attorneys to consider all of the following: the scope of the issues, the date and time of the hearing, the list of witnesses, the schedule for exchanging experts' reports, any circumstances that would affect the arbitrator's impartiality, and exhibits, documents, or other information the parties consider relevant. The parties can reach an agreement with the assistance of the arbitrator, but if they do not, the arbitrator must issue a decision on all of the issues that have been submitted to arbitration within 60 days after the end of the hearing. There are advantages and disadvantages to arbitration. The advantage is that a binding decision is made by the arbitrator, much the same as a judge would make. The disadvantage is that the decision of the arbitrator cannot be appealed to the Michigan Court of Appeals, where a decision by a judge can be appealed. Whether a particular case is appropriate for arbitration is determined on a case-by-case basis. This is just a short overview on arbitration. More information can be provided by contacting me either by telephone at area code 248-593-9090 or through my website, www.judithblumenau.com.